Então.
Podem começar. Muito obrigada, me desculpem.
Não, que isso.
Good morning, everyone. Good afternoon, good evening, depending on where you are based. So today we are very happy to have you all here with us for the book launch of our book called Climate Litigation in a Changing World, a Comparative Analysis of Similarities, Challenges, and Pathways. This event will be in English and Spanish, so we're gonna do both. And to start today, we have with us right now Professor Gabriel Vedi. Professor Gabriel Vedi is a postdoctoral degree in law from PUC Rio Grande do Sul with a research period at Columbia Law School, Sabin Center for Climate Change Law, and at Universität Heidelberg Institute for Deutsch and Europäisch. And I'm sorry because I'm not fluent in German, so I will end here. And he's also a professor of the graduate program in law of PUC Rio Grande do Sul, where he teaches climate law. He's also a federal judge in Brazil. Professor, you now have the floor to present your book chapter. You have 10 minutes, and if needed, you can use 2 or 3 minutes longer. So thank you again for being with us today, and now you have the word.
Thank you. Good morning, distinguished colleagues. Allow me first to congratulate the editors, Professor Cláudia Aquino, Valéria Loureiro, and Vinícius Abrantes, and the publisher Springer Law for an innovative and timely volume, Climate Litigation in a Changing World. This lecture draws on my chapter, Climate Disinformation and Climate Washing, Litigation in Defense of Human Rights and Transparency. Co-authored with my colleague, Professor Elisa Mafazioli Hartwig. We stand at the intersection of two accelerating crises, the stabilization of the Earth's climate system and the corrosion of our information ecosystem. Disinformation is now ranked the most severe near-term global risk, with extreme weather close behind. Their interaction manifests in climate disinformation and its market-facing variants, greenwashing and climate washing, is not a peripheral concern. It is a structural threat to human rights, environmental democracy, and the rule of law. By climate disinformation, I mean the organized, non-accidental dissemination of misleading content that undermines the scientific consensus on anthropogenic climate change, its impacts, and the urgency of mitigation and adaptation. Its contemporary posture is less denialism than revisionism. Narratives that normalize delay, individualize responsibility, or promise salvation through speculative technologies. In this gray zone, greenwashing and climate washing allow corporations and public bodies to claim climate alignment while capital expenditures, lobbying, supply chains, or financing practice tell a different story. The empirical record shows sustained investments in narrative management that outstrip verifiable shifts towards low-carbon business models. Why is this a rights problem? Because this deception is not costless speech. It degrades the conditions for collective self-government, truthful information, deliberation on shared facts, and informed consent, especially in moments of climate-charged disaster, when engagement maximizing platforms can impede evacuation, misdirect resources, and burden the rights to life and to information. The climate crisis is an inequality multiplier. Disinformation intensifies that inequity by masking harms, deflecting accountability, and polarizing publics. Environmental democracy grounded in access to information, meaningful participation and access to justice cannot function where the informational substrate is intentionally distorted. The legal architecture is already at hand. Commercial speech receives protection, but deception is regulable. In US law, the FTC Act and the state UDAP statutes reach unfair or deceptive environmental claims. Securities, anti-fraud rules, policy material misstatements to investors, and climate salient disclosures increasingly occupy a defined regulatory space. Internationally and comparatively, the Aarhus Convention and Escazú Agreement and the Bali Guidelines entrench procedural environmental rights. Due diligence and vigilance regimes require companies to identify, prevent, and mitigate human rights and environmental risks across value chains, and regional human rights jurisprudence recognizes affirmative states' duties of transparency where environmental harms threaten health and life. Litigation has begun to align these trends. A rights-based third climate case invoking life, health, a healthy environment, and a safe climate now converge with suits that challenge climate disclosures, greenwashing, and climate washing as forms of actionable deception. The thesis is straightforward. Misleading climate communications are not merely marketing defects. They are rights-relevant harms because they disable informed participation, conceal environmental injustice, and rationalize delay whose burdens fall heaviest on vulnerable communities. Illustratively, New York's action against JBS challenges net zero by 2040 as materially misleading in light of supply chain emissions and the land use impacts. Client Earth's challenge to an EIB biomass loan tests climate transparency in public finance under access to justice guarantees. Litigation in the Brazilian Amazon contests carbon credit monetization premised on traditional communities. Stewardship without free, prior, and informed consent. Vigilance claims against BNP Paribas scrutinize finance links to deforestation against the banks, public commitments, and regional human rights adjudication, has condemned states' failures of active transparency amid industrial pollution. Across forums, the true line is consistent. Climate washing is the informational surface of deeper rights violations. What follows for courts, regulators, and practitioners? First, recalibrate scrutiny. Treat environmental claims as you would any high saliency commercial representation. Omissions can mislead as powerfully as affirmative falsehoods. The test is not whether climate science is debatable. It is not, but whether the communication is truthful, no misleading, and substantiated against a settled scientific baseline. Second, operationalize due diligence. Declaration of net zero or carbon neutrality must be anchored in credible IPCC-aligned transition plans with clear guardrails. No substitution of low-quality offsets for real emissions reductions, no double counting, transparent Scope 3 accounting where material, deforestation-free supply chains, and governance that ties incentives of science-based targets. Where financing predictably enables rights harms, financial actors, policies and representations should be measured against robust human rights and environmental risk management. Third, center procedural environmental rights, access to information, participation, and justice are not adornments. They are constitutional infrastructure. Enforce proactive, transparency, timely publication of climate risk assessments, due diligence reports, and the methodologies underlying net zero pathways so that communities can see, be heard, and obtain remedy before harms crystallize. Fourth, demand evidentiary rigor. Courts are not venues to relitigate anthropogenic causation. They are venues to test whether claims align with facts. Expert testimony should illuminate accounting choice, offset, quality, scope 3, materiality, and the technical feasibility and timelines of promised technologies, filtering marketing through empirical constraints. Let me close with clarity. Climate washing is not harmless branding. It is actionable deception that corrodes environmental democracy and enable rights violations. We do not need novel doctrines. We need factful, urgent application of the ones we have, such in advertising, anti-fraud, due diligence, and procedural environmental rights calibrated to the stakes that climate science makes plain. The path forward is concrete. Scrutinize and where necessary, enjoin misleading claims, require verifiable transition plans, enforce access to information and participation, and impose remedies that restore information integrity, corrective statements, independent audits, governance reforms, and active transparency by public bodies. In climate matters, trust is not a courtesy. It's a legal and democratic duty. Aligned with scientific reality, climate litigation can do more than punish falsehoods. It can safeguard the rights that make self-government possible and accelerate the only just pathway left, immediate, transparent, and verifiable emissions reductions. Thank you very much.
Thank you very much, Professor Gabriel Veggi, for the amazing presentation, as always. Undoubtedly, it's one of the most important issues that we fight misinformation, we fight climate washing, so we can work on assuring procedural rights, such as the access to justice, access to information, and public participation in the decision-making process. So thank you very much for presenting. And now I will, since Professor Ana Bonet is with us, Professor, I would like to ask you, gostaria de perguntar se está bien para empezar. And thank you once more, Professor Gabriel Veggi, for presenting with us today. Entonces, si no hay problema, primeramente, muchas gracias, profesora Ana Bonet, por estar con nosotros hoy y también por su ponencia. Es un honor para nosotros tenerla con nosotros hoy. Y entonces voy a empezar haciendo su presentación y después tienes la palabra. Entonces, la profesora doctora Ana María Bonet es pesquisadora a la CONICET y es también pesquisadora asociada en Global Studies Programs, FLAXO. Es también una postdoctoral fellow CONICET. Tiene doctorado en la Universidad de Bremen, en Alemania. Tiene maestría también en Alemania, en la Universidad de Freiburg. Y es también abogada. Es mediadora, doctora del Socio-Eco-Legal Research Team y es también profesora, si no me equivoco, profesora, porque estoy haciendo la traducción ahora, pero es también profesora en Argentina de la Universidad
Católica de Santa Fe.
Católica de Santa Fe, perfecto, muchas gracias. Y también la profesora es una visitante pesquisadora visitante de Max Planck Institute for International Law y también pesquisadora visitante del Instituto de Sostenibilidad de la Universidad de Kassel en Alemania. Profesora, muchas gracias una vez más. Tienes la palabra para hacer su presentación de su capítulo. Muchas gracias.
Bueno, muchas gracias por la invitación. En primer lugar, muchas gracias por la invitación a participar del libro. Fue un gusto para nosotros poder participar. A los 3 editores, muchas gracias por la oportunidad, en primer lugar, de participar del libro y segundo, de poder participar hoy también de la presentación. El texto que propusimos nosotros como capítulo se trató de la huella ecológica. Propusimos trabajar con el concepto de huella ecológica como una herramienta para la toma de decisiones en el campo de la litigación climática. Y la idea central del capítulo se centra en el potencial del concepto de huella ecológica como herramienta jurídica clave para abordar el cambio climático y las crisis socioecológicas, especialmente en el campo del litigio climático, en tanto permite medir impactos, atribuir responsabilidades y cuantificar daños. El artículo parte de un problema, de la identificación de un problema que tiene que ver con algunos límites que detectamos en el derecho ambiental tradicional. La primera cuestión es que vemos que el derecho moderno aborda la cuestión ambiental principalmente a través de la evaluación del impacto ambiental, la planificación urbana o el ordenamiento territorial. Serían como 3 dispositivos. Podríamos detectar más, pero bueno, nosotros detectamos un poco a modo ejemplificativo también 3 límites, digamos, de la cuestión ambiental, como es abordada de manera más clásica. Estos instrumentos, como los límites que detectamos estos instrumentos, son que se centran en impactos puntuales y cuantificables, no captan efectos difusos, acumulativos o sistémicos, y además se apoyan en última instancia en una lógica antropocéntrica. Vemos sobre todo la cuestión del impacto, las evaluaciones de impacto ambiental ponen el acento en los efectos negativos, pero vemos que las problemáticas ecológicas muchas veces tienen problemáticas difusas que no logran ser, que no podemos esperar hasta que se traduzcan en un daño negativo. Vemos que en ese sentido que el concepto de huella ecológica tiene potencial para poder mostrar algunas incidencias de ecosistemas que no logran ser captadas por el daño ni por el ordenamiento territorial. Entonces proponemos con el concepto de huella ecológica un cambio de enfoque en la cuestión del daño ambiental, porque entendemos que este concepto puede ayudar a medir, o sea, el concepto mide los recursos consumidos, las emisiones generadas, los residuos producidos y los impactos sociales de las acciones humanas. O sea, hay una metodología que inventaron unos canadienses que permite calcular la superficie necesaria para sostener un modo de vida. Es decir, a través del cálculo de huella ecológica, se puede calcular a través de se puede cuantificar los costos ambientales, los costos ecológicos, socioambientales, digamos, ecológicos, del sostén de un estilo de vida o de una acción humana. Y eso nos tiene potencial para acciones no solo preventivas, sino también para responder a ciertos daños, para calcular la responsabilidad. Y entendemos que tiene potencial porque además no ubica tanto a la cuestión ecológica en la cuestión ambiental, sino considera también lo social y nos muestra los límites planetarios, que es algo que veíamos que en un enfoque tradicional de la cuestión ambiental no venía siendo considerado. Entonces, el concepto nos permitiría 2 cosas. Por un lado, pasar de un enfoque fragmentado de lo ambiental a uno integrado que considera también lo social, y por el otro lado, pasar de un enfoque centrado en los efectos a uno centrado más de manera preventiva en las responsabilidades. Entonces, el concepto, en resumen, permitiría 3 cuestiones. Poner en cuestión un enfoque antropocéntrico del derecho, de la perspectiva jurídica. Por otro lado, sería un concepto que articula o que muestra una interdependencia entre humanos y no humanos, es decir, que no solamente centra la cuestión climática en una cuestión ambiental, sino que también considera lo social, porque considera el ecosistema planetario no solamente como una cuestión de ambiente, sino que de convivencia socioecológica. Y por otro lado, introduce la lógica de relaciones, porque el ecosistema está basado en relaciones. Entonces desobjetiviza a lo no humano, a la naturaleza, que ya no es considerada solo ambiente o entorno, sino que permite reconsiderarla como en un vínculo con lo humano. ¿Cómo esto se traduciría en el ámbito del derecho? Detectamos también 3 posibilidades. Permite identificar responsabilidades, incorpora límites a decisiones públicas y privadas y permitiría también diseñar políticas públicas. Y se podría plasmar tanto a nivel individual, como a nivel empresarial, como a nivel estatal. A nivel individual, por ejemplo, para calcular el impacto ecológico que podrían tener las acciones humanas, por ejemplo, uno podría calcular cuál es la huella ecológica de un alimento que uno está consumiendo, es decir, cuántos recursos fueron necesarios, cuántas emisiones se generaron para poder producir ese alimento, qué sociedades fueron afectadas por el producto, por la producción de ese producto, y además cuántos residuos, qué impacto en residuos se han generado para producir ese bien. Concretamente, ¿cómo podría ser utilizada este concepto de huella? Detectamos que podría ser utilizada tanto de manera preventiva como de manera ex post, es decir, después de que se produzca algún efecto negativo. De manera preventiva podría ser utilizada, que vendría a ser cuanto más potencial tiene transformador, podría ser tanto en la administración como en lo regulatorio. Permitiría fijar límites y objetivos. Por ejemplo, cuando se invierte en alguna infraestructura, uno no solamente podría evaluar el daño ambiental, por ejemplo, de la construcción de un puente, de la habilitación de una fábrica, sino además del impacto ambiental concreto, que estaría medido más bien en daños, uno podría pensar en qué huella ecológica genera ese puente. Y esto implicaría mucho más que pensar solamente el impacto ambiental, sería negativo, sino además qué implicaría esto para las generaciones futuras y qué huella no solamente negativa, sino positiva está dejando. Esto nos permitiría también establecer nuevas formas de relación causal, en donde la relación causal no está solamente dada por un daño, sino también podría permitir medir otras relaciones de causalidad. Uno también podría ser responsable por algo positivo, que hoy en día no está, por ejemplo, un viaje en avión. Uno en principio no puede decir que genera un daño ambiental en términos de daño ambiental tradicional, pero sí tiene una huella ecológica. Y uno también podría ser responsable por esa huella que está generando ese viaje. O lo mismo, construir una casa. Construir una casa, en principio, en un pensamiento clásico tradicional, no genera un daño en términos ambientales, pero sí deja una huella, porque cuando uno no está más, queda una huella en el ambiente, en el ecosistema. Podría llegar a ser, en términos administrativos, por ejemplo, ¿cuál sería una medida administrativa que podría habilitar este concepto de huella? En algunos lugares ya se está pensando en la idea de que cada ciudadano pueda llegar a tener a largo plazo créditos ecológicos. Por ejemplo, que yo en mi vida pueda llegar a tener 1000 créditos. Y esos 1000 créditos los puedo ir gastando. Eso se haría calculando cuántos recursos tiene el planeta y cuántos podría tener cada uno de los humanos que estamos viviendo hoy en día para que todavía siga siendo sustentable la vida en el planeta. Entonces, cada ciudadano podría llegar a tener tantos créditos y una vez que los termina, bueno, tendría más limitaciones para poder seguir gastando. Uno podría decir, bueno, uno puede gastar tantos créditos y bueno, cada vez que viaja gasta créditos, cada vez que carga gasolina gasta créditos y bueno, podría llegar a un límite y después de ese límite puede ser que tenga que pagar. Eso tendría una limitación porque, bueno, aquel que puede pagar podría gastar más, pero también implicaría que el que supera su capacidad de gastos, es decir, que está generando más huella que la que tiene permitida o más huella que los demás, también tenga que asumir ese costo de la huella que está generando en el planeta. Eso sería algún efecto en términos administrativo. Y en términos judicial, nos podría servir para probar el daño ambiental, pero de una manera diferente, porque ya no implicaría solamente un daño negativo, sino que sería mucho más amplio y más difuso. Uno podría decir, bueno, no se está generando un daño concreto hoy en día, pero hay una huella que está generando esta actividad, por ejemplo, o esta inversión, o esta infraestructura nueva que estamos generando, de la cual uno también se tiene que hacer responsable. ¿Cuál es el costo de esa responsabilidad? Todavía se puede discutir. También podría, como decía, establecer nuevas relaciones de causalidad con otras acciones con las que hasta ahora no están siendo previstas en la litigación climática, permitiría cuantificar daños también y aplicar algunos principios preventivos y sobre todo el principio precautorio. O sea, acá tendría mucho fuerza el principio precautorio. En cuestión de litigio climático, podría contribuir a evaluar algunas conductas empresariales, o sea, podría llegar a servir para evaluar las conductas empresariales y también para poder analizar de una manera un poco más integral algunos casos de climate washing, por ejemplo, para poder demostrar alguna publicidad engañosa en relación al cambio climático, que a veces si uno lo ve solamente desde la evaluación de lo que es daño ambiental, no llega a ser detectado como dañino, pero sí desde un concepto más amplio como el de huella ecológica. Y también podría llegar desde un punto de vista reparador a contribuir para establecer responsabilidades respecto de las acciones positivas a las que está obligada una empresa, por ejemplo, para compensar los efectos que está teniendo en el ambiente. Entonces uno podría, si bien a veces puede ser que un determinado emprendimiento no tenga un daño ambiental, puede ser que llegue a ser responsable de tener que tomar algunas medidas para compensar la huella ecológica que está generando en el ambiente, ¿no? Por ejemplo, podría llegar a compensarlo con créditos de carbono, podría llegar a evaluarse, pero habilitaría una comprensión más amplia sobre determinadas responsabilidades que hoy en día no llegan a estar determinadas en el concepto de daño ambiental. Entonces, bueno, en conclusión, nuestra propuesta es incorporar el concepto de huella ecológica en principio, y ahí vemos dos potenciales, un conceptual más discursivo que permita no centrar la cuestión de la responsabilidad ambiental a una cuestión a la cuestión del daño, es decir, no limitar la responsabilidad al daño, sino pensar también en aquellas acciones que, aunque no sean un daño, también nos pueden hacer responsables. Por un lado eso, y por otro lado, en una medida más concreta para acciones preventivas que nos permitan anticiparnos a posibles efectos que, aunque hoy en día no puedan ser considerados dañosos, a largo plazo y si uno lo contempla en modo ecosistémico, sí podrían tener efectos negativos en la convivencia planetaria. Así que bueno, ese es un poco el contenido nuclear de nuestro artículo. Esto es una invitación a que lo puedan leer, también a que lo podamos discutir, y es también una primera invitación a introducirnos en este concepto y a seguir estudiando el potencial que podría llegar a tener no solamente para la litigación climática, sino también para revisar y para repensar también algunos principios del derecho ambiental a largo plazo. Así que bueno, un gusto otra vez poder estar acá con ustedes, poder compartirles esto y la invitación a leer no solamente este artículo, sino todo el libro también. Muchas gracias.
Muchas gracias a ti, profesora. Fue maravilloso oírla. Bueno, esta temática es una temática que me gusta mucho porque lo que proponen ayuda muchísimo para la evaluación del daño y es muy difícil. Entonces, es muy valioso y rico que proponen porque es una mirada distinta de lo que ya tenemos. Es una mirada que propone ir más allá y tener una mirada también ecocéntrica y no antropocéntrica es que necesitamos en esto. Yo tengo una pregunta porque me gusta mucho la temática y estoy aprendiendo con usted hoy muchísimo. Me gustaría preguntarte sobre el impacto en el campo de los derechos de la naturaleza. Si piensas que lo que propone puede alcanzar el concepto de derechos de la naturaleza y si quizás en países que ya ya adoptan derechos de la naturaleza, como por ejemplo Bolivia, Ecuador, si lo que propone quizás aumentará los casos de litigancia de derechos de la naturaleza. Yo sé que esta temática quizás el tiempo quizás no sea suficiente para tratar, pero me gustaría oírla un poquito, escucharla un poquito más sobre eso.
Claro.
Me gusta mucho. Muchas gracias.
Un gusto, muchas gracias por la pregunta también, sí, muy interesante. Yo creo que justamente el concepto tiene potencial para articular o para adaptar el derecho ambiental a el discurso del derecho de la naturaleza, porque el derecho ambiental, en principio, al entender lo no humano como ambiente, como entorno, de alguna manera lo objetiviza, y eso sería contrario a la idea de derechos de la naturaleza. En cambio, el concepto de huella ecológica, lo que habilita justamente al salir un poco de la idea antropocéntrica. La idea antropocéntrica pone al humano como sujeto y a la naturaleza como objeto. Entonces, ahí está difícil reconocer derechos a la naturaleza en una perspectiva clásica de derecho ambiental. En cambio, la idea de huella ecológica tiende a pensar la convivencia planetaria, es decir, el planeta como un ecosistema. Y dentro de ese ecosistema habría diferentes seres con los que convivimos, los humanos y seres no humanos. Entonces, el concepto de huella ecológica, que presupone el concepto de ecosistema planetario, sería mucho más alineado con el concepto de derechos de la naturaleza que la perspectiva clásica del derecho ambiental, que protege a lo no humano como naturaleza, como ambiente, como objeto en función del humano. O sea, la protección ambiental más clásica es en función del humano, no afectemos el medio ambiente para protegernos nosotros. En la idea de huella ecológica está mucho más esta idea de convivencia planetaria, una convivencia que tiene en cuenta lo humano y tiene en cuenta también a lo no humano. En ese sentido, entiendo yo que sería más compatible con los principios de los derechos de la naturaleza, con el enfoque de los derechos de la naturaleza. Si bien no lo restringe, yo entiendo que los derechos de la naturaleza en este caso serían como una herramienta jurídica más, como para proteger a lo no humano. Podría haber otras también, ¿no?
Perfecto, muchas gracias, profesores.
Un
Tenemos
gusto.
algunos comentarios, que es un evento sensacional. Qué alegría escuchar a la profesora Ana María y excelente pregunta. Profesora, muchas gracias una vez más. Y bueno, fica la invitación para que lean el capítulo de la profesora. Muchas gracias. Y ahora seguimos con la presentación de Adriana Di Pasquale y también Julia Schutz Vega. I will change now to English because I suppose they're going to present in English, right? Just to confirm. Okay, perfect. So thank you very much for being today here with us. And I suppose it's afternoon right now, so good afternoon. And now I'm going to present both authors. Adriana Di Pasquale, she is a PhD in International and European Law from University of Pisa and at the University, the Federal University of Ceará. And Julia Schutz Vega is a visiting fellow at the Nippon Foundation Ocean Voices Program, University of Edinburgh, and a PhD candidate at Nova School of Law, Universidade Nova de Lisboa. So thank you very much for being with us today. You now have the floor. You have 10 minutes to present your work, but if needed, you can use 2 or 3 minutes longer. So thank you very much for being with us today, and now you have the word.
Thank you very much, Valeria, for your introduction. It's a real pleasure to be here with you, with my dear friend, Julia. And I have the book here in my hand, so I'm very glad also to have it with me. It was really a pleasure to work with you and to be part of this amazing book with so many interesting contributions. So I will just start. Me and Julia, we co-authored the chapter 6 of the book alongside Professor Tarim Montalverne, who couldn't be here today, but has sent her best for all of us. And I will introduce the chapter first, and then Julia comes and gives her brilliant presentation. So our chapter is entitled Dive into the Synergies Between the Climate and the Ocean Emergencies, and Analysis of the International Tribunal for the Law of the Sea, Advisory Opinion on Climate Change. And we have produced this contribution within the book about climate change, climate litigation in the changing world. And we really found it was very important to try to establish this connection between climate change and also the law of the sea and many related issues to the ocean, because sometimes it's not a connection that we can establish in such a obvious way. Sometimes it might seem that it is not that obvious that they relate to the climate change with the ocean and marine resources and marine biodiversity. So we tried really to show this connection to make it more feasible for the public, for people who are going to read the book. And then, so we start from the 2030 agenda, just trying to show how every SDG, we have 17 SDGs, and we have one SDG, which is SDG 14, which is dedicated to life on water. So we have the 2030 agenda as an important document, since it tries to cover all aspects of the environment, and it has fragmented these different areas, life on water, climate change, and so many others. But it comes with a different approach. It comes with a systemic and holistic approach, showing that it doesn't matter if they are different SDGs, but they are all related to each other. They all depend on each other to be achieved. So we show how SDG 14 is important to achieve all other SDGs, such as SDG 1, which is no hunger, and many others. So it's very important to adopt these more holistic view when it comes to environmental issues. And after that, we try also to demonstrate how climate change affects ocean resilience and ocean health. So we have the ocean as the major carbon sink in the world. It absorbs most of the excess of carbon dioxide that is emitted to the atmosphere. So the ocean is very important for us to mitigate and adapt to climate change, but it also is facing problems because of climate change. We have ocean acidification, we have pollution from GHGs and also from other debris. We have a reduction in marine life. So they are situations, phenomena that are interrelated, interconnected, and have this reciprocity. The ocean is important to overcome the climate changes, but it also is affected by it. So we establish these connection to understand how international law views the situation. So we go to international law and also demonstrate how international law is fragmented. We have many fields in international law, climate change law, we have human rights law, environmental law, also the law of the sea. And all these issues, when we talk about the environment, they are all connected, but sometimes law is not that obvious to establish these connections between these different instruments. So we go to UNCLOS, which is the Constitution of the Ocean, the international, the convention, the United Nations Convention for the Law of the Sea, and the Paris Agreement, and we try to see if they are connected, how they could establish some connections. So, for example, the Paris Agreement from 2015 does not predict how the ocean is affected by climate change, but in its preamble, it shows that the ocean is important to overcome climate change. So, one of the ways the states, the United Nations member states could oversee this connection is through their NDCs, their national determined contributions. They could establish measures for the ocean, for protecting the ocean, protecting marine biodiversity, considering how it is affected by climate change. This is just one example. And the other example, that is the one that we bring in our chapter, and that Julia is also going to go deeper on it, is the case 31 of the ITLOS, which is the International Tribunal for the Law of the Sea, that published an advisory opinion regarding the responsibility of states when it comes to climate change and the protection of the ocean. So Julia is also going to talk about it. So these are examples on how international law is evolving to predict these connections, to recognize this connection and these synergies among different agendas. The climate change one, the ocean one, the biodiversity one. So we have really to try to go beyond these different agendas and try to see the entirety of it, such as how the example we have of the 2030 agenda, that is really these different approach trying to understand better all these issues and how they are related to each other, and also trying to give the possibility to most vulnerable communities, such as the SIDS, the Small Island Developing States, to overcome problems that they are most vulnerable of. So it's mainly that our chapter. We try to establish the connections, then we go to case theory one of the ITLUS, and we finish with this analysis of the regime complexity, which is really these connections between different international regimes and how they they can contribute to each other. They can establish synergies, or we can just realize challenges and try to overcome them. So we have these different ways to understand this complexity, but the best one is really to try to see how they can really work together and help each other, and then we can have the best solutions for these environmental issues. And also climate change litigation and other environmental litigation are also important to try to overcome some gaps that international law was not yet able to foresee. So it's also very important to have people and entities litigating for these environmental issues, so we can advance more on this situation, on this crisis. That's it, Julia. I give you the word. Thank you very much.
Well, thank you, Adriana. Thank you, Valeria, for inviting us for this moment. It's a pleasure to work alongside with Adriana and Tarim in this chapter. So, okay. So Adriana brought us this understanding about this big umbrella of how is everything interconnected, trying to find or to establish the bond between the regimes. But what ITLUS did a few months ago, actually a year and something, was truly establish this nexus between climate change and the law of the sea. So basically, the case study is this intervention traces how small island developing states, the SEADs, have strategically leveraged their structural vulnerabilities into legal and political agency in these global climate governance. So a key milestone during this chronological pathway was the 2014 Samoa pathway. And basically, they established a coordinated framework to address the specific development challenges of SEADs. And the focus was mobilizing international support, strengthening follow-up mechanisms, and facilitating collective engagement. So this recognition was reinforced in the 2030 agenda that Adriana already mentioned. And building on this foundation, the SEAD translated this vulnerability into collective diplomatic power. So they started working together in the 90s, and it started playing a central role in climate negotiations. So more recently, this evolved into a more jury-defied, if I can say that, strategy with the creation of the Commission of Small Island States on Climate Change and International Law, or the acronym COSIS, in 2021. And through this establishment and this innovative institutional design, so they have the authority to request the advisory opinion from the International Tribunal for the Law of the Sea. So they open, they asked for the court a clarification of states' obligations under UNCLOS in the context of climate change. So this is like the case 31. The initial was December 2022. And the core of the request was precise and also ambitious. So causes asked ITLUS to clarify to what obligations the states parties have under UNCLOS to prevent, reduce, and control marine pollution arising from climate change, including ocean warming, sea level rise, and ocean acidification, and to protect and preserve the marine environment in light of these impacts. So ITLUS, considering its competence in Article 21 of the statute and Article 138 of UNCLOS, the case attracted significant engagement with a lot of stakeholders, a lot of, states and organizations submitting opinions about the case. And in our work, we try not only to do this chronological history of the case, but also highlight some important things from the advisory opinion. So we listed here in this presentation 3 reasons. So firstly, it establishes the ocean climate nexus. So it was recognized that anthropogenic greenhouse gas emissions constitute a form of marine pollution, thereby bringing climate change within the scope of Part 12 of UNCLOS. Secondly, it interprets Article 192 dynamically. So the obligation to protect and preserve the marine environment extends beyond the prevention and control to include restoration of degraded ecosystems. These represent a significant development and expand the scope of state obligations. Thirdly, it clarifies the applicable standard of conduct. So there is this reflection on. So ITLUS frames these obligations through a due diligence standard requiring states to adopt all necessary and appropriate measures within their capacities and in light of available scientific knowledge to prevent, reduce, and control marine pollution caused by climate change, and give some examples, so some context-sensitive standards of conduct. And finally, the opinion emphasizes the systemic integration through Article 237 of UNCLOS. ITLUS calls for harmonization of these external regimes, reinforcing the need for coherence between law of the sea and climate change law. So in sum, this case demonstrates how seeds have moved from vulnerability to kind of leadership in this protection of the environment. So I hope you read the chapter, you enjoyed the chapter. Thank you once again for inviting us to be here. And we are, here to, explain something more or to provide any question that you may have. Thank you very much.
Thank you very much, Dr. Adriana Di Pasquale. Thank you very much, Dr. Julia Schutz-Vega. For us, it's such an honor having you both here. I wish Professor Tarin was also here, but I understand. Well, first of all, amazing work. Amazing work. It's one of the fields that for sure we should address more often, because when we talk about climate change, I feel like we always talk about climate change under a human rights perspective, but hearing other issues such as marine pollution, and also how you brought this issue connecting to SDGs and so on, it's an amazing perspective. But I have one question. Well, for sure, this advisory opinion number 31 is undeniably very, very, very important for the field of climate change. But I was wondering, since you both have deeper research and knowledge in this field, I would like to know if you think that this advisory opinion should have covered something else. So, for example, I know we're talking about the scope of the UNCLOS Convention. So basically, we are talking about this very important treaty of law of the seas. But my question is basically to understand if there's anything, like any point that the advisory opinion should have covered, or if in your opinion it was like enough the way it was brought, or if they should have addressed human rights obligations, as I said. So thank you very much once more, and I'm looking forward to hearing from you.
Should I go? Okay. Yeah, well, first of all, I think one of the most problems, if I may say, it's like the enforcement of international law. So always when we have not only a proper sentence, like a decision, it's already like difficult, like to do the enforcement of that. So imagine the advisory opinion. So it's like more or less kind of okay, this is the reference. Okay, you should like follow this principle. This is like, you know, your light. So follow the light. But on the other hand, it's an international law court providing an opinion. So basically, there are not only one specific point, but a lot of, you know, kind of like a comma that I would love to say, but blah, blah, blah. So I think there are some, sorry, some points that we could go a little bit deeper. So for example, acidification or something like that, you could go a little bit deeper to say, okay, how we can, you are giving me the connection, you are giving me the problem, but you're just like saying, okay, apply the due diligence and that's it. So why not elaborate a little bit more about some examples that they brought to the discussion? But this is like my personal view. I know that there are people like more excited with the advisory opinion. I don't know if Adriana wants to add something, but I think this is like one of the points.
No, I was one of the people that was very excited with the advisory opinion, because if I'm not mistaken, it was the first one that recognized this climate change intervention in the ocean. So it is really a huge step forward for us. And I guess they responded very well to the proposed questions of the SIDS. They could obviously go further, even further, but I guess they were very reasonable in their opinion, and it was an advancement. I personally would like them to have recognized, for instance, plastics as one of the type of pollution caused also by climate change, because we have this relationship between plastics and fossil fuels. But I guess it's a little bit too much, so I was very happy with the advisory opinion.
Baby steps.
Yes. We can always go further. But a little bit later, after this advisory opinion, we had an AO, I guess, as well from the ICJ. They're recognizing the climate change and human rights relations also. So we are moving forward little by little. So I'm happy.
All right, so thank you very much, you both. It was an amazing presentation. And now to continue the presentation, I have here with us, thank you, bye-bye, girls. If I'm not mistaken, I have here with us Sharon and Mariana. Mariana is here already. Who else is here? Let's see. Well, since I don't see Shuma and Sharon yet, I will start with Mariana Coferi. Then you can correct me if I mispronounced your name. So Mariana, thank you very much for being with us here today. It's such an honor having you here. And I will present you in a minute, sorry.
I know, I entered a little bit earlier.
No worries. Just finding your chapter here so we can properly introduce you. So Mariana, thank you for being again with us here today. So Mariana is a master's candidate in law at Centro de Ensino Unificado de Brasília. She's a postgraduate in international law specialist at Faculdade Damaso de Jesus in São Paulo, and she's also a Bachelor of Laws at União Pioneira de Integração Social, a Bachelor of International Relations from the Institute of Higher Education of Brasília, lawyer, specialist in international law and civil appeals. She's a public servant at the Ministry of Justice and Public Security, working at the Department of Asset Recovery and International Legal Cooperation. Mariana, what a great CV, right?
Oh, thank you very much.
Congratulations. So, Mariana, feel free. You have now the floor to start your presentation. You have around 10 minutes, 12, 13 minutes. So if you need longer. Okay. So yeah, please feel free to present it. So thank you once more.
Thank you very much. Good morning to everyone. Thank you, Doutora Valéria, for this reception and for this invitation. It's a real pleasure to be here today. It was a great work, and it's a pleasure to present to you all. I would like to begin by noting that my co-author, Dr. Tiago Romero, unfortunately could not join us due to a prior professional commitment. Therefore, I have this honor to present the core arguments of our joint chapter entitled El Hinani's Legacy and His Contribution to Climate Litigation. This article advances two main claims. First, it argues that the concept of environmental refugees introduced in 1985 remains normatively relevant despite not being formally codified yet. Second, it proposed that climate litigation functions as an indirect yet effective tool to protect vulnerable populations. So these are the two main claims of the article. In other words, even in the absence of a binding legal framework, courts and legal actors are already expanding the protection through interpretation of the human rights-based ideas through litigation. So this is the main idea of what we are trying to present. The starting point of this work many years ago, when I was a postgraduate student with Dr. Tiago, started with the recognition of a clear gap in international law mentioning this. So we can see all the evolution of the world and all the evolution of the climate changes, and we don't have a legal structure following this. The 1951 definition of refugee, as you know, does not include environmental factors. So as a result of this, millions of people are displaced by climate change, environmental degradation, and disasters still remains outside legal protection. And based on these ideas, we find the concept of El Hinanis, and it becomes crucial to starting to think in how we can improve and provide legal protection to vulnerable populations in this area of climate changes and environmental migration. In 1985, as mentioned, El Hinanis proposed a broader definition of environmental refugees. So he established the definition and proposed not only a descriptive definition, but it shows with examples the real problem. It included individual displacement by natural disasters, long-term environmental degradation, and human-induced harm. So these are three different definitions to try to feel more people and feel more protection in this area. For example, we have natural disasters like cyclones and earthquakes. That is something that sometimes we cannot mention and cannot provide, but we still have the consequences. So we have to try to find a legal system to bring this. But more important than this is to prevent. So when we talk about long-term environmental degradation, we can see this going through. So we have to try to find a legal system that foresee the situation and provide the legal protection. So it's important to mention that it was not merely descriptive. It represents a paradigm shift in the area And as we can see, and I hope you find it in our chapter. And to better understand this phenomenon, as in this paper, El Hinani classified environmental displacement into 3 categories: temporary, permanent, and progressive. As I mentioned, this division, it is important to understand better the situation and to reflect how we can move along with the legal system. Together, they reflect different temporal dynamics and structural causes of displacement. And based on this first part of the article, then we identify climate litigation as a key mechanism for holding states and corporations accountable, demanding mitigation and adaptation measures, and protecting fundamental rights, as we know, living broadly and living with security is a fundamental right. So we have to keep this in mind. Nowadays, courts are increasingly linking environmental harm to human rights violations, thereby expanding states' responsibility. We have to keep this in mind, that the state is responsible even though it's a natural disaster. So we have to understand how make the state responsible. And it comes and it creates a new scenario from a law perspective. This leads, as I mentioned, to a new scenario of states' responsibility and due diligence. So the states may be held responsible not only for their actions, but also for omissions, particularly when environmental harm is foreseeable. So this is why it's important to classify the type of the climate change and the type of the environmental situation, to understand if the state is responsible by action or an omission, and to bring to a Brazilian concept and example, we have the situations of the Mariana and Brumadinho Dam, that it was an omission of the state, perfectly foreseeable, and nothing has been done, and we have this major tragedy. So this is a slight scenario that we can think. Another scenario that about more progressive environmental change is when we see the Kiribati situation. It's an archipelago that it's being consumed by the sea, caused by the climate change and the uprising of the seas, and the population that lives there, they don't have where to go. So are they refugees? Yes, environmental refugees, because they have this situation where they have to move without the will to another place, and how we can receive this person. So these are the situations to think about and exemplify our discussions, and that we bring a little more described in the chapter. So despite nowadays we have a few advances, we have a few cases discussed climate litigation, significant challenges remain, as which the absence of a unified legal definition. We don't have this environmental refugees definition in any convention. So maybe starting with this, we can think in more aggressive measures to improve this. The lack of a binding international instrument and weak enforcement mechanisms, as the former speaker mentioned, it is really difficult to have enforcement mechanisms if we don't have a binding definition, and if we don't have a binding mechanism to do it. And for this reason, I think it is essential to continue advancing this discussion in papers, in books, and in forums. So this is the importance of the academic part, right? Keeping thinking and advancing the discussion to try to bring something from this. It is important to understand that the concept of environmental refugee is not obsolete. It is underutilized. Nowadays, it is underutilized. climate litigation represents to me and Dr. Thiago, as you can see in the paper, the most viable short-term pathway to recognize rights, promote legal evolution, and reduce global asymmetries. We know that the most affected populations are from small countries with difficult economics, and the big ones who have the power to do something about it are not thinking about this, are not thinking about the legal protection and the climate changes as they should. So it's something to reaffirm and to try to. Ultimately, El Hernan's legacy is not merely historical, as we mentioned, it's structural, is important for the future of international law. We can start with this concept that he mentioned, and he started in 85, and nowadays he's more important than ever. It reflects a broader transformation from a reactive legal system to one that is preventive, solidaristic, and global. So, keeping all this in mind, I hope you read the chapter. It's just a small presentation of the article. I was not trying to present all the data and information, but it's to just open this discussion on environmental displacement and the role of international law, and having in mind that is the most pressing challenge of our time. It's a big challenge for us. It's a big challenge in the law area. So I think we have to try even more talking about. And as a final thought, the law does not only respond to reality, but has the power to shape it. And that's what we should do with this. Understand the situation, the evolution of the climate change, understand the vulnerability of the population who are classified in El Hernan's concept, to try to find a preventive legal system, even better to try to solve future situations that may come. So thank you very much. I hope it was a nice presentation for you, and I look forward for the next opportunity. Thank you.
Thank you very much, Mariana. For sure, it was an amazing presentation. And personally, when I read your chapter along with Professor Thiago Romero, it made my eyes shine, because it's the subject of my PhD thesis. So as soon as I read it, I was like, oh, this is amazing. So thank you for sharing with us your insights. As I say here, we have this book launch, but it's just a small spoiler to make people curious and buy the book and read and contribute as well to the discussion. So thank you very much for bringing this very valuable perspective. And yeah, like El Hinawi for sure is one of the most important person in this field, because he was the first one to bring this issue under attention. And it was a time that people weren't even talking that much about climate change, but he was talking about environmental refugees. And then from environmental refugees, we have the climate refugees, which is under this more same concept. And I believe, like, when we say, because there are many people that they don't like say, oh, there's no such a thing of environmental refugees or climate refugees because it's not in the 1951 convention. But I say that the terminology, the concept itself, it's more of a political choice. And for me, since I am an environmental and climate activist, and I work in the field of advocacy and campaigning, I will keep using this term, because for me, they are climate refugees. Although some other people, they prefer the terminology climate displaced persons or people or climate migrants. I think it's important recognizing that the 1951 convention was made in a time like a post-Second World War. So it needs to be how do I say, updated. So it needs to be improved. We need to acknowledge that there are other rights that should be recognized under that convention. So we should like think in a broad perspective. So that's why when I say climate refugees or environmental refugees, I always make the reference to the Cartagena Declaration, the 1984 declaration, because when we think of massive human rights violations and circumstances that disturb the public order, for sure, climate change and environmental disasters, they are under this definition. So that's why in Latin America, we have countries that allow climate displaced persons to come, to migrate. Although not refugees, again, due to political issues, but we're advanced, we're making some progress here. So thank you once more for your amazing presentation. And well, once more, we invite you to read her chapter along with Professor Thiago Romero. Thank you, Mariana. It was a pleasure having you here.
Thank you very much. I couldn't explain better myself. Thank you for your contribution.
Amazing.
I hope we can see each other again in a shorter time.
Thank you very much. And now to proceed, we have two more presentations. We have Sharon Murioki with us, and we also have Shuma Talukder. So I will start now with Sharon Murioki. Sharon, just 1 minute because I will introduce you. So just let me get back to the book and then we can start. So 1 second. Well, once again, thank you for being with us here today, Sharon. Such a pleasure always having the opportunity to hear you and hear Shuma. Always amazing presentations. So to introduce Sharon Murioki, Sharon, she holds a master's degree in colonial and post-colonial studies from Linnaeus University. And she's also holds a postgraduate diploma in law from Kenya School of Law, LLB from Moi University. And she's a country ambassador for Human Rights Measure Initiative. She's an advocate of High Court of Kenya, Nairobi. And also, we should update this. She's also a master student from law student from Lewis and Clark, if I'm not mistaken. You correct me if I'm wrong. So please welcome again, Sharon. You have now the floor to present your chapter. So thank you for being with us today.
Thank you so much, Dr. Valeria. Good morning, everyone. Good afternoon, good evening. I just loved the previous conversation with Dr. Mariana because my chapter starts with the environmental refugees, like internal environmental refugees who are an indigenous community in Kenya. They sued the Kenyan government in 2010, the Ogiek people, and the African Commission was like, you need to compensate these people or return them to their land. And what has happened for over 16 years is that nothing has happened. And the concept of people being displaced from their land for development is something that is continuing. So I'm with you, Dr. Valeria. We have climate refugees, no matter what we call them, people are displaced. And that is the point of my chapter, that the law, sometimes we approach the law thinking we'll get protection, but the law sometimes, and the enforceability part of the law, aspect of the law is kind of tough, especially because of costs and all types of laws being promulgated every day to keep justice. So my paper takes 3 approaches: Kenyan courts, East African courts, and the Africa court system. And the reason for this is because climate change is not localized in a nation. It's global. And sometimes here you may find yourself having to go to another court, like an international court, to have your rights protected. Climate justice is international, and that is why I wrote about that. So my background is about climate financing. We have this carbon credits thing going on. And going back to my Ogiek case, it is mostly happening in lands where indigenous communities are settled. that is where these companies coming up with carbon credits, corporate governance memos and policies are targeting, and they are being encouraged by governments to do their what would we call it now? Is it to atone for their sins for committing crimes against the environment? They are being settled into these communities that have indigenous communities, in these lands that have indigenous communities. So I approach my paper by talking about Kenyan laws, because apart from the environment itself and climate change acts and statutes, we have other statutes that may affect both the communities, the government. Is legal aid available? What is the role of lawyers in all this? And that is how I have tackled it. We have if you go to like most of the African countries, you'll find that we have specific climate change laws over the last 10 years or so. Especially after the Paris Agreement, you will find parliaments have sat, come up with laws, government have sat, come up with policies. So it's an emerging area, and with everything, I have not gone to the sea here. Literally, I've dealt with it on the land. It's a matter of socioeconomic rights. I have approached it from a socioeconomic right, and this is the right, economic and social rights, and how do these laws displace these people from their land? If I'm coming to, let's assume I'm coming to talk to a community about the effects of climate on their land and their cows and their family setup, what law do I use to approach them? It is not the Climate Change Act that I will use. I may have to use the land laws. I may have to use my training as a lawyer, my license to address them. I may tell them you have to go to court, we can do this and that, and compel the government to protect you. So I have approached it from all types, from the judiciary level, from the training and what we need to do. And climate justice overlaps with all types of laws, whether they're national, international, or municipal laws. Even the local town law it can be used to promote climate justice. And why am I doing this at this time? Like I said, the laws are very fragmented. So I thought of coming up with a book that will, thank you so much for the book. I have it. I don't know if you can see it. It arrived, and I have dealt with the issue from the constitutional point of view. I have used the Lamu cold case, where people have been successful in ensuring that justice, community justice, the Lawyers Act, what happens when you start from the lowest level and you go to the top level, what processes do you have to go through? Can we arbitrate these cases? Sometimes we can, sometimes we cannot. So we have to be very careful what we put in the contracts and the agreements that we come up with, because some terms of the agreement may have communities in court for years without resolutions. And it's about energy, it's about the consumer. The consumer here is usually the people who are being affected. It's about the environment, it's about justice. And I also go to the East African Court of Justice because the East African Treaty we have 8 countries now, and we have some shared resources. So we may find that if the laws are not working in a certain nation like Kenya, we are moving to East African Court of Justice. So what happens there? Are we likely to get justice? Is it enforceable? We come to the problems of international law, like I started my chapter with. And then I go to the African Court. It's very long. We call it the African Court. It's easier to see it like that. And like we have seen with the Ogiek case, very hard to enforce its judgments against national governments, and the process of approaching the African Commission in Banjul. So my conclusion is that the costs, like everywhere else in the world, the cost of going to court, getting a plaintiff, paying their bus fare to go and litigate. And if they are hit with cost by the court, if they lose the court, the process, and who is going to pay the cost for the lawyer and for the other party? Government disinterest, with the Ogier case being a perfect example, and also emerging areas of laws. We have all the time somebody coming up with a rule, a regulation, a statute to cover the basis of something that was not covered when the previous law was implemented. And something I know I should have written in my book was about standing, like how do we approach the issue of standing? But it's something I would like to do independently because it's very long. It was, this would take like 30 pages. It would need a whole new chapter. So Dr. Valeria, if you have future plans to write on that, please let me know. I would like to approach the issue of standing as a freestanding issue. So thank you so much.
Thank you very much, Sharon. Always great to hear you. Great presentation. Yeah. I'm just wondering, because I was sharing your presentation here, but I suppose people couldn't see. I'm not sure if you could see that I was sharing, right? So maybe we have a technical issue.
It's okay.
Maybe, yeah, I tried to share. So maybe if people couldn't see, I'm sorry. We're facing some technical issues today, but great presentation. I'm very happy to hear you. And it's very important. Personally, it makes me very happy when I hear people from the global South bringing their perspective, because sometimes I feel like researchers from the global North, they have this bad tendency to put Latin America all together in a sack, African countries all together in a sack, as if we were like all the same. But bringing perspectives per country, as you did, is amazing, because not only we can learn the way it works in each country, because you shared that perspective in the chapter, but we have this opportunity of like understanding that Africa, such as Latin America, is so diverse that law here, of course, is not the same as law in MENA countries, like in the northern part of Africa and so on. So bringing this perspective, bringing this insight as you've made it, it's very, very important and very rich. So thank you again once more for sharing your contribution. It's always a pleasure working with you and Shuma. So thank you, Sharon. And now I have some comments here. So I see that there are some comments congratulating Adriana and Julia, Dr. Mariana and Dr. Thiago for the interesting chapter. And there is one for you, Sharon. Dr. Sharon Muruyuki, it's such a pleasure to hear you talk about this topic. Indeed, it is. So it makes me really happy having this opportunity of learning with you, learning from you. So thank you once more,
Thank
Dr.
you so much.
Yes. And now I will proceed with the presentation of Shuma. Shuma, are you here with us now? Yes, you are.
Yes.
Thank you very much. Shuma, well, I will introduce you, and then as Sharon and as the other speakers, you have 10 minutes, up to 12, 13 minutes if needed. So thank you again for being here with us, and it's always a pleasure working with you. It's very, very rich partnership that we have working together. So Shuma is a corporate lawyer and governance professional. She's also a PhD research scholar at Mahendra University, Hyderabad. So please correct me if I'm mispronouncing. Her educational qualifications include BA, MPA, LLB, LLM, and business law. And she holds professional membership of IUCN, WCEL, Biodiversity Law and Climate Change Law, Specialist Group, and Ethics Task Force. Her scholarly publication include a co-edited volume, and which I also invite you to read and buy, because it's also published by Springer, which is called Judicial Responses to Climate Change in Global South, a jurisdictional and thematic review, which I had the pleasure to co-edit with her. and papers in peer-reviewed journals and edited collections. She has also published in popular media and presented at international conferences in Asia, Europe, and North Africa. And congratulations for the very rich CV. So, Shuma, now you have the floor, so please feel free to present your work. And just to let people know, Shuma is facing some technical issues, so that's why she's going to present with her camera off, but we can still hear her, we can still comment and interact with her. So Shuma, thank you once more. You have now the word.
Thank you so much, Valeria. It was so nice to listen to my previous speakers as well as to listen to you. It's really an enriching experience, and it's a privilege for me to be part of this book release event. To briefly share the essence of my chapter, which is on challenges to climate litigation in India. Generally, when we talk about climate litigation, we think that in case of any climate harm, we can approach court for demanding justice. In theory, of course, we can approach court, we can demand justice, but practically, when we try to do it, especially in a country like India, there are a lot of challenges. So my chapter is primarily dealing with the challenges that we face in India while putting across the climate litigation. Before approaching to what are the challenges we face, I would like to briefly introduce you to the current status in India related to climate law. Our previous speaker, like Sharon, mentioned that in Africa, in most of the countries, they have climate laws, especially after the Paris Convention. In India, still we do not have any climate law. Though we have environmental laws and special court like NGT, National Green Tribunal, that primarily deal with environmental cases. We have laws for controlling pollution, for protecting forests, law for protecting wildlife, but these laws are not designed specifically for climate change. We can say it's like we are trying to fix a modern smartphone problem using a tool meant for old radio. So we are still not updated. Courts here use generally environmental laws to deal with climate issues. As climate change is a global issue, again, our previous speaker mentioned that it's a global issue and domestic laws just can't handle it. We need to handle it globally. Complex and long term. The existing legal system in India, therefore, is not, it's very fragmented and unclear, and it's not capable enough to deal with the issues of climate change. Coming to the challenges that we face in climate litigation in Indian courts is first is problem of causation. That is, the court might ask that can you prove that this specific action causes this specific climate harm. So connecting both is very difficult. Climate change is not like a car accident where causation is very apparent and we can easily connect issues and cause. For example, if a flood destroys a village, it is very difficult to prove whether it is because of one factory or because of government policy or because of global emission. So that's one primary challenge we face in our courts. It is extremely hard to prove the direct link in case of climate litigation. Second problem that we face is still very strict rule of standing. That is, who can file a case. Not everyone can approach the court. For example, if a farmer is suffering because of climate change, it is very difficult to prove that he is suffering because of climate change. So as a result of this, access to justice becomes very difficult because they don't have a standing before the court. Thirdly, we can say cost and time of limitation. I think it's an issue with most of the developing countries, underdeveloped or developing countries, that litigations are quite expensive and it's also time consuming. So most of the time, the petitioner, they lose the patience, and of course, cost is a very huge financial, that liability is a big expense, which many times they are reluctant in accepting it. So climate change are quite expensive, time consuming, and also require scientific expertise. For example, if a community fighting a polluting plant may not afford a long legal battle, This creates an imbalance between ordinary people versus the powerful companies, those who are operating in that area. The fourth issue that we face is a scientific complexity. In case of climate litigation, courts rely heavily on scientific evidence. Climate science is a complex, and our judges are not efficient enough to handle those scientific issues. This again makes decision making in climate litigation very difficult. The next problem could be judicial activism and limits of court. Now coming to a country like India, we have three different pillars in democracy, that is legislative, executive, and judiciary. So if judiciary, the function of lawmaking lies with the legislative, not with the judiciary. So in case if there is some, let's say, laws are weak, in that case the court has to step in and make some laws or policies to address that issue, which legislature many a time they fail, not only because they fail, they do it willingly because of lack of political will. So this raises a question that should court make climate laws, or it's the government who should address it. For example, court tries to, we can take one case where court tries to balance solar energy projects with the protection of endangered species. So in this case, it shows that there is a tension between environment, development, and government. So it's like they feel that legislature feel that judiciary is trying to step into their shoes and make the law. So there is a very tension that continuously goes on between legislature and judiciary. The next this obstacle that we face is corporate influence and lack of political will. Sometimes powerful industries influence policies. For example, during COVID-19, we have noticed that there are reports of efforts to weaken environmental rules. This makes climate litigation even harder because of the lack of political will and corporate lobbying. I think this is common in most of the global south countries. And lastly and finally, lack of awareness. So many people are unaware of climate rights. Even lawyers and judges may lack specialized knowledge. So even strong cases, often we see it fails because of lack of awareness and knowledge of how to address it. So in simple terms, India has many environmental laws, but no clear, strong climate laws. Courts are active and innovative, but limited by legal and scientific challenges. People are affected by climate change, but still struggling to access the justice. So way forward, what India needs is a comprehensive climate law, a better use of scientific evidence in court, easier access to justice for the communities, stronger political commitment, and greater public awareness. I'll close my presentation with a final thought that climate litigation has a great potential. It can push government and corporations to act. But today in India, it is like a powerful tool that is not yet fully sharpened. It can strengthen our laws and system. Climate litigation can become a key driver of climate justice. Thank you.
Thank you very much, Shoma. It's always brilliant. It's amazing having the opportunity to hear your presentation. So brilliant presentation. Thank you for sharing. And I couldn't agree more. Indeed, climate litigation and also environmental litigation is time consuming. So that's why some people, they end up giving up, sadly. And indeed, this field of climate litigation, along with environmental litigation, I think one of the issues indeed is the scientific complexity, not only the aspects you mentioned, but also, of course, the damage itself, which links to the presentation made in Spanish by Dr. Ana Maria Bonet. And basically, when we think about environmental damage and climate damage, we have issues such the extension of the damage, the causality, and so on. And it is important that we have works such as your chapter to address this issue, because the more and more we write and research about it, the more we can help the judges to decide, hopefully. So thank you for sharing. And also, I gotta add here to everyone that is listening to us, that is interacting somehow with us. We have some comments, great insights. Dr. Shuma, excellent presentation and chapter, Dr. Shuma. And we have one information here is that everyone watching can use the 20% discount voucher, which is in capital letter SPROUT, SPRAUT. So please use this voucher when buying our book. And thank you, Shuma, once more for your presentation. So
thank you
now,
so much, Valeria. And thank you. It was I enjoyed listening. So I could listen to only 2 presentations, but I really loved it. Thank you so much.
Thank you once more. And now, Leslie, my presentation, it won't take long because sadly we are running out of time, and I will make the presentation in Spanish. So that's why we're going to shift. But I would like to thank in advance to everyone watching the presentations here, everyone that attended the book launch. It was very important for us having you here. And as I said, this presentation here is basically a spoiler of our book. So please, if you have the opportunity, buy the book, because we'll have the opportunity of reading such rich book chapters, such rich papers that will contribute more and more to the development of this field, the field of climate litigation and human rights protection. Entonces, ahora para terminar, yo voy a hacer una pequeña presentación de mi capítulo que escribí junto con Marlon Rosa. Entonces yo tengo el libro aquí. Vean que es un libro muy bonito, que la capa es dura. Entonces, si tienen la oportunidad, por favor, compren. Bueno, mi capítulo es un capítulo que escribí con él sobre litigios climáticos en la Oceanía. Y bueno, no voy a hablar tanto porque todo que fue hablado hoy, todo que fue presentado hoy, de una manera u otra, es también lo que hablamos. Por ejemplo, que habló Julia y habló también Adriana, es un poco que hablamos, porque cuando pensamos en litigios en Oceanía, estamos pensando también litigios de pequeños estados insulares, en islas. Entonces, que hablaron es muy importantísimo para esto, que habló también Mariana, porque Mariana, cuando habla de El Hinawi, que cuando trae la definición de refugiados ambientales, refugiados climáticos, estamos pensando en la situación de las personas que son desplazadas climáticas en Oceanía. Y tenemos un caso muy importante que yo digo que es un caso quizás lo más conocido, que fue en el sistema oceano, que fue el caso, un momento que yo quiero abrir el capítulo acá, que fue el caso de un ciudadano que planteó una queja, un caso contra Nueva Zelanda, porque, bueno, este ciudadano de Kiribati mudó, y este ciudadano que se llamaba Ioanni Teichiota se mudó a Australia, a Nueva Zelanda, porque no tenía más condiciones de vivir en su país, porque su país, por ser un pequeño país insular, una isla, es uno de los países más afectados por la crisis climática. Es una emergencia climática sin dudas. Entonces, ¿qué pasó? Es que fue allá, pero el país no reconoció la concepción, la terminología del refugio climático, pero la ONU dije una cosa muy importante, que es el non-refoulement. El principio de no devolución es muy importante acá para entender este caso, porque mismo que no exista ahora una definición de refugiado climático, no puede un país enviar otro por causa del principio de no refoulement. No puede devolver a esa persona que ha dicho que no tiene más condiciones de vivir allá, sea porque no tienes tierra para cultivar, porque su seguridad, su salud, su moradía, todo esto está en peligro. Entonces, cuando la ONU reconoce eso, es un marco en el régimen internacional climático. Bueno, podemos hacer más. Y esto que estamos intentando hacer más y más con los casos de litigación climática. Un otro muy importante que traemos también es el caso de Daniel Billy contra Australia, que fue también en el Comité de Derechos Humanos. Y este caso también fue emblemático porque la ONU entendió que sí había una violación de derechos humanos, que el país no estaba haciendo suficiente en relación a la crisis climática, y que los habitantes del estreito de Torres Strait Islanders, los habitantes del estreito de Torres, estaban teniendo su estilo de vida amenazado, su salud, su vida, su seguridad. Entonces es una obligación de Australia de garantizar eso. Y bueno, yo estoy yendo muy rápido porque no tenemos mucho tiempo más, pero lo que trabajamos en este capítulo muy sucintamente es que hay una diferencia de los litigios que se pasan en Australia, en Nueva Zelanda, y los litigios de otros estados, los pequeños estados insulares, porque la mayoría de esos estados están teniendo problemas de desplazamiento forzado, de desplazamiento climático. Entonces, esto es el centro de la problemática. Mientras en Australia y Nueva Zelanda tenemos otros problemas, pero mucho más ambiental do que climático. Entonces tenemos litigios internos en esos países, pero de empresas que están contribuyendo muchísimo con polución ambiental, y que el país no está haciendo mucho por disminuir los gases de efecto invernadero. Entonces, bueno, hay esta diferencia. Entonces, como yo ya hablé con Sharon en Shuma, que no se puede meter los países de Latinoamérica todos juntos, no se puede meterse en un saco todos los países de África, no se puede hacer eso también en Oceanía, porque hay esta diferencia. Mientras mismo que Australia y Nueva Zelanda estén en el sur, no son considerados para todos los fines como sur global, porque tienen características complejas muy distintas de los pequeños estados insulares que hacen parte también del continente. Entonces, es necesario tener un cuidado, una mirada especial cuando analizar esos conflictos en el continente de la Oceanía, porque hay esta diferencia. Y es una diferencia muy gritante. Entonces hay que entender que lo que se pasa en Australia y Nueva Zelanda, mismo que el efecto de la triple crisis planetaria del cambio climático afecte a todos los países, es obvio que no afecta de manera igual. Los países que menos contribuyen para la crisis climática, infelizmente, son los que más sufren con los efectos. Entonces, esto es lo que queríamos presentar. Claro que si tienen la oportunidad de leer el capítulo, van a aprender mucho más. Hay mucho más datos, hay informaciones sobre países que son signatarios de tratados internacionales de derechos humanos. Hay otras informaciones allá, pero como no tenemos más tiempo, esto es que me gustaría presentar. Entonces, una vez más, muchas gracias a todos que presentaron hoy, thank you very much once more to everyone that had the opportunity to share with us today their presentation, their insights, their very, very, very rich book chapters. So thank you once more. And well, hopefully you can all buy the book. Once more, the discount voucher, the 20% discount voucher is Sprout, SPRAUT. Entonces, una vez más, el cupo de descuento de 20% es Sprout, SPRAUT. Entonces, no pierdan esta oportunidad. Muchas gracias. Ahora paso la palabra para la profesora Claudia para que haga sus consideraciones finales. Puede hacerlo en portugués o como quieras, en inglés, en español. Ahora tienes la palabra. Muchas gracias.
Congratulations. Thank you for your presentation. E vou finalizar em português, porque nesse momento estamos no Brasil.
Estamos cansadas também. Estamos cansadas.
Muito. Parabéns pela organização do livro. Gostaria também de parabenizar o professor Vinícius pela parceria, né, e principalmente a Valéria por ter liderado toda essa iniciativa da apresentação deste livro, que já havia sido lançado no ano passado, né, Valéria? E por conta da organização da agenda dos speakers, da editora, então conseguimos realizar o lançamento somente nesse momento. Mas foi uma grande experiência, uma excelente oportunidade, como eu disse aqui no chat, foram excelentes autores, grandes artigos e ótimas apresentações. Eu acredito que ainda existe muito a avançar na discussão deste tema, das externalidades das mudanças climáticas, e foi um prazer e um privilégio poder trabalhar com autores e organizadores que debatem, discutem e refletem muito sobre o tema. Então, sem delongas, gostaria de parabenizar mais uma vez a todos, principalmente a Valéria, que está aqui, deixar um abraço para o Vinícius e dizer que estamos aí prontos para novos projetos e novas oportunidades. Agradecer a todos que participaram e espero que possam ler os nossos artigos que estão lá registrados no livro. Muito obrigada.
E se eu posso só finalizar, eu também quero agradecer, né? Eu acho que faltou da minha parte no início ter falado, né? Porque como a gente já estava um pouquinho atrasada, eu acabei esquecendo, mas eu queria agradecer principalmente você, Cláudia, você, Vinícius, por terem acreditado no projeto, por terem topado fazer isso junto, porque a gente sabe, né, o trabalho que dá, não é assim, vou publicar um livro, daqui 2 meses estou pronto, né? Então, tem todo um trabalho de revisão, em alguns casos até de tradução. Então, eu agradeço muito essa parceria, agradeço muito à editora Springer, so thank you very much, Springer, for trusting once more in our work, for allowing us this amazing opportunity of sharing insights and perspectives about climate litigation around the world. So thank you once more to everyone that watched and all the authors that trusted our work, all the authors that shared something very important with us, which is the issue of climate litigation. So thank you once more. Muito obrigada a todos y gracias a todos que confiaron en nuestro trabajo. So, un abrazo. Gracias.
Abraços, obrigada.